Jazakumullah khairan. Inshallah, our session on Islamic laws of inheritance and will be taking place after dua. All brothers are requested to participate. Bismillahir Rahmanir Rahim. Allahumma salli ala Muhammadin kullama dhakirun wa ala salli Muhammadin kullama ghafala dhikrul ghafilun. Allahumma ighfir warham wa tajawaz amma ta'lam innaka antal a'izzul akram. اللهم يا مصرف القلوب صرف قلوبنا إلى طاعتك يا مقلب القلوب ثبت قلوبنا على دينك اللهم أرنا الحق حقا وارزقنا اتباعه وأرنا الباطل باطلا وارزقنا اجتنابه يا ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وادخلنا الجنة مع الأبرار يا عزيز يا غفار يا رب العالمين وصلى الله تعالى على خير خلقه محمد وعلى آله وصحبه أجمعين. Bismillahir Rahmanir Rahim. Alhamdulillah. Alhamdulillah wa salatu wa salam ala Rasulillah. Amma ba'd. Yesterday we started the conversation in relation to the importance of how we live our life and how we depart from this world. And the last thing that we discussed yesterday, which was an action point for all of us to go back with, was determination of our wealth and estate. So, as a reflection point, it's about each one of us pausing and thinking, if I was to pass away today, what belongs to me that will be distributed? Because it's what belongs to you, not in your household, what belongs to you as an individual that matters. Yeah? So I hope we didn't have any domestics over the last 24 hours about this sofa, this half is mine and this half is yours, or whatever. But on a serious note, it's about identifying. So if you went home based on my advice and said to the missus, everything in the house belongs to you, then if you were to pass away today, then those things won't be considered as part of your inheritance. However, if she was to pass away, and may Allah preserve her, you've got to give those du'as at the same time. Otherwise, you know what you get to here, you know how it goes. Anyway, so if she was to pass away, then all those items will be calculated in her assets. Yeah? So we've got to keep that in mind. So determination of estate. And let me just give you one or two examples. Those that are married and of a certain age, because nowadays the young generation are much more shrewd than we are, is we buy the house, and what do? Buy in joint names. Yeah? So, our houses are in joint names with our better half. And when those houses are in joint name, there could be two scenarios. Both partners are working and both pay towards it. Or one works, the other manages the house, So when you bought that house on joint names, what happens? So when people come and ask me, what's up, we need to sort out my inheritance or my late father's inheritance, my first question is, okay, the house. Whose name is it? Oh, it was in joint name. But was it your father's, or was it your mother's, or was it 50-50, or was it 60-40, was it 70-30? So if it's one person's, then, okay, belong to your father's, so then it will form part of inheritance. If it was joint name, then was there any clear distinction between the percentage of ownership? Now we don't know. Then we just got to arbitrate in between. How do we arbitrate? Based on custom and culture. So we would just say it's our 50% each, and let's get the ball rolling, because there's no clear understanding. You have a joint bank account. So the money that's in the bank, is that joint ownership or not? Because again, if that was joint bank account, is that 50-50%, or the husband's wage was coming in there and he used to run the household and the wife is 50% owner, or just able to benefit without any questioning? Yeah. So if there's £10,000 in your bank account, right, and you're the only breadwinner in the home, and now the wife is able to dip into that bank account and use it as she wills, because you've granted her that benefit, the money remains yours, yet she is able to benefit. So if she was to pass away, then that bank account wouldn't form part of her inheritance for discussion. But if you were to pass away, 100% of what's in that bank account will form part of inheritance. Does that make sense? And that's why it is vital, important, must, fard, obligatory on every individual to identify what belongs to whom. Because without that, you can't move any further. So the first step of action was determination of estate and wealth. There is a discussion about joint tenancy and tenancy in common. Yeah? Just something, sometimes, as I said, joint ownership. So sometimes you can have joint ownership under joint tenancy. So what normally happens, if one person, two people's name are on the house and under joint tenancy, then as soon as one person passes away, it goes into the name of the other person, because they are both equally owners of that house. They have the right amount of same power and same autonomy and everything else, and they are equally owners of the house. So if one was to pass away, it automatically transfers over to the other, because the other person has 100% control over it. Got that? The downside to that is, if the other spouse said, I'm not going to give this house away, because where am I going to live? So they sort the inheritance out, but not the house, because I've got to live somewhere. And legally, law of the land, when I say legally, that she has the right to continue staying in there because of joint tenancy. Islamically, 50% of the house need to go into inheritance. If there's dindari in the family, then the wife will say, I know legally I have this house, but 50% belong to him, and therefore it needs to form part of inheritance. You're now relying on people's amanatdari and trustworthiness, and otherwise legally you don't have a leg to stand on. Yeah? on this one point, let me mention one other thing. Sometimes parents buy a property or a house on the son's name for whatever reason. But it is always understood that it is the father's, but he's bought one house on Abdullah's name, one on Ubaidullah's name, and so on and so forth. But although the deeds will say the house belongs to Abdullah, Ubaidullah, somebody else, Islamically the house belongs to the father, and therefore it will form part of inheritance. So you can't only just go by the deeds and what they say. It's got to be about Islamic ownership. Does that make sense? Now again, sometimes it might come to bite you. Yeah? You put it on your son's name as they've grown up and the father's passed away. The son just says, yeah, that house is on my name. Yeah? So legally he has the right. Islamically doesn't. Tenancy in common is slightly different. It is again joint ownership. However, both individuals have a determined share in the property. They have a determined share in the property. It is all just legal jargon that they mention. But what happens in tenancy in common, when one person passes away, that share is not automatically transferred to the other person. Yeah? Also, in tenancy in common, the person can say in his will that my share needs to be distributed likewise. And that can happen. But in joint tenancy, even if you include it in your will, it can't happen because it's already transferred to the other person. So that's something for you to think about. Obviously, tenancy in common is more recommended from an Islamic point of view because you can put in instructions and you're not just relying on other person's amanatdari and honesty. Yeah? However, if there's dindari, as I said, neither of them will make any difference. And I mentioned about furniture in the house and utensils and everything else in the house, regardless of how insignificant the matters are. And I've just couple of things I just want to highlight over here. Yeah, that every big and small items left, regardless of its insignificant value, will form part of the estate. Yeah. And do you know when somebody passes away, again one of the common malpractice that takes place, if Abdullah's passed away, the family will just get all their clothing together, yeah, put it into bin liners, and then give it to a welfare trust charity box. Yeah. Now, you haven't even sat down to discuss about the inheritance. All those clothing were of value. All the clothing we wear, they have some value to it. That's why we wear it, to adorn ourselves. So when that person passes away, those clothing had a value and needs to form part of the estate. To the point, scholars have written that when a person passes away and the person who is giving the ghusl, if he can remove the clothing that the deceased is wearing without ripping it, it is not permissible for that person to tear the clothing and dispose of it. Yeah? So that pair of clothing that he was wearing, if that can be taken out and put towards the estate, then it needs to be put towards the estate. It is only when it's not possible that you need to cut it through. Yeah? And this is a point for those that give ghusl to keep that in mind. Sometimes you have certain items of the deceased, yeah, may seem insignificant to you. but it belongs to the deceased, it needs to go to the family. Yeah. Also, before any distribution has taken place, before any distribution, pay attention please, before any distribution has taken place, everybody has a share in every item. Does that make sense? Before distribution has taken place, every item is owned by every inheritor. So you can't just say, this pair of clothing, I'll just sort it out, right? And then we'll sort the rest out. I don't have the authority on that one pair of clothes. Although what I will get as a share might be 10 times as much as that. But before distribution, each item has everybody's share in it. So pre-distribution, those items cannot be managed as you will. It needs the consent of everybody who is going to inherit. So it is better just keep everything as it is. Keep everything as it is until you come to the point of distribution, and at that time you then sort it out. Or if everybody is adult and you have those discussions, abata kaprato, do anybody need anything from it? If not, shall we just give him charity? Everybody consent? Fine, move on. Yeah? When there's, as I mentioned yesterday, if there's minors involved, you need to be extremely cautious. And you will hear me repeat this over and over again. Because minors can't consent, and the guardian of the minors can't consent on their behalf. In these kind of matters, the guardian, so if that's the mother, if the father has passed away, leaving behind a young child, like Aus bin Thabit left that small child, the mother can't consent, I give permission on behalf of my young child to dispose of the clothing. They can't consent like that. Yeah? What you need to do is value it, put their share to one side, and then can consent. One of the problems we also face, yeah, and your imams will tell you, is people will say, oh, he passed away, left behind 2 homes, but a month before he passed away, he said, this house is gifted to my son. Yeah? So the house I'm living in is gifted to my son. And there are people that come to this Sufa Institute, I know of them without naming or disclosing anything. Right? They say, my son lives with me. All the other kids have been settled. I've helped them get by their houses in their lifetime. The youngest is living with me. Na agar to inutse, pan abito marutse. Ma barwapati. So I said to him, just give it to him now, because after you pass away, it will be all the children's share in it. Because and that's a fear. And sadly, not stone throws away from here, there are incidents just sadly in our community where that has happened. Yeah? So I understand the fear, but you can't have your cake and eat it. So you've got to keep that in mind, that when is a gift Islamically acceptable or not? You've got to take physical ownership of it. Yeah? When I transfer something, if I say to you, Junaid, I give you this pen. Yeah? You all heard it. You're all witness to it. Good. Junaid now puts a claim, right? That I happen to pass away, the pen is still in my pocket. Junaid puts a claim. Majidno Barine, he said that this pen I give to you. The Maulana will say to you, yeah, he might have said it, but he never gifted to you. Why? Because I didn't transfer the ownership to him. I kept it in my pocket. I kept it in my pocket. I didn't give him access to it. That gift is waste of words. Yeah? Gift hasn't happened. So the possession needs to be transferred. So when a person says, I was involved in somebody's inheritance in Fulwood, they had many properties. The person passed away, and the wife and the family said to me, you know, he left all these properties 3-4 months before, and said to me, I'm just making a name up, Aisha, this is all yours. Yeah? That's it. That was the one conversation they had. Now, 4 months on, he passes away. Nothing has changed in the running of those houses or tenancy and everything else. Now the claim that that wife makes, that all these houses belong to me, is invalid from a Sharia point of view. Why? The possession hasn't been given. So my question to her, 4 months ago when she gave you all these, when he gave you all these houses, if you wanted to sell any one of them, would you be able to sell it? And she goes, no. It wasn't transferred in my name. Nothing was given to me. It was just verbalized. Just by verbalizing, that gift does not happen. And one last example regarding the house. You know, if that father and the son situation I told you wanted to give the house to the son, he can't continue to stay in the house and gift it to the son. So I'm living in the house, my son is there with me, I take the keys out and I say to my son, yeah, Dikra, I give you this house as a gift, here's the key. All my stuff is in the house, I am still living in the house, that gift is incomplete. Islamically, that will not be a valid gift. Yeah? The house needs to be vacated by the owner and then given it to the son. The son comes in, you come knock on the door, Beta, can I come in? And if he says no, he sent you packing your bags, basically. That's what you call a gift. In gifting, the other person's got to have complete autonomy over that item that you are gifting. I'm trying to make it as clear as possible.
Can you not make a will then?
We will come to the will later on. Yeah? We're coming to the will. So just be patient a little bit. But this is what I mean by physical ownership, means that the receiver is totally free to dispose independently with whatever has been gifted to him. Does that make sense? Yeah? The other person who you've gifted it now has complete right over it. If that such ownership is not established, then although you will all have all these witnesses and claims and everything else, from an Islamic point of view, the Maulana will say, sorry, that will form part of the estate and everybody else will have a share. I've already kind of touched on this. Yeah? Are we okay with this? Move on. So let's quickly move on about what happens. When a person dies, their wealth will be used and distributed in the following manner. So, firstly, as soon as somebody passes away, everything that belonged to him doesn't belong to him anymore. Yeah? So everything needs to stop. Everything needs to stop. You've got to determine what belongs to him. Now, out of everything that belongs to him, you can use the money for certain things. Firstly, for the burial cost. So regardless of what it will cost, a moderate amount, the going amount will be used. So if that is £2,000, different cities up to £4,000, £5,000, whatever the going moderate rate is of that particular community and area, that's the money that you will use out of the person's assets to pay for the funeral. So that will include, transportation, what if there is ghusl cost, if there are shrouding cost, grave, coffin, all those kind of things. That cost, a moderate amount will be taken. So a person passed away, all his assets total up to £10,000. The funeral cost is going to be £2,000. £2,000 you can dip into the pot to pay for those costs. Yeah? You can't pay for the headstone. Yeah? So you can't dip into the pot for the headstone. For the grave, yes, not for the headstone. You can't pay for the guests that are coming and you're going to feed them. On St. George's Road, of course it's such a long road, that's why I named it. I was involved in somebody's inheritance discussion. Yeah? When janaza time, nobody really pays attention. People go and the family members go ahead and sort out everything. Food arrangement was done for the next 2-3 days. Anyway, months later, when the inheritance was being organized and distributed, everybody started claiming, to Matadar uncle we ordered, that dargosh for everybody, that cost me X amount of money, therefore I need this money back, and so on and so forth. You can't claim that money. You spent it, there is the second time you're going to cry. Yeah, first time when the marhum passed away, second time when you found out that you can't claim that money that you spent. Yeah? Bill par aave chapre. So any additional cost cannot be dipped out. This is purely burial cost. Clear? If there's any money left, how much money have you got left? £8,000. Yeah? If there's any money left, then you move on to stage 2. If there's nothing left, there's no discussion further. But if there's any money left, where we've got £8,000 left, then we've got to find out if there's any debts outstanding. Any debts that are outstanding. So you've got to find out if that person owed money to anybody. And that could be individual, that could be your credit card, that could be any kind of loans or whatever that might be. That will need to be cleared off. That could be the bill that has come, the utility bill, phone bill, gas bill, electric bill, whatever that might have come, that's already come, you've got to clear that. On this point, and I do appreciate people find me a bit strange when I start talking about these things. Yeah? But that's the reality. That when that person passes away, his life meter's gone. Your utility meter also needs to be frozen. So if that reading was 5001 on that gas meter when he passed away, now you're sorting out inheritance, and over the next 10 days that gas meter's been running because everybody's been coming and you've used the electricity and the gas and everything else, and that's gone from 5001 to 5050. Those 49 units you've used, You can't take it out from the marhum's thing. Therefore, some of our elders were so cautious, that until inheritance was distributed, they wouldn't even go to that house to do taziyat. Yeah? Because you're going in and now people are just living normally and then deduct it from here. Because that meter that you're going to, the meter reading that you're going to give or sort out is going to be possibly weeks later. Yeah? My advice is somebody at that time just takes the meter reading, so at least you're clear from where his account stopped and where the inheritance account began. Clear? So the bill that is up to that point is a debt on this person. Anything after the person passes away, then it's not a debt on the individual. Clear? And about making sure that everybody is clear about who do you owe the money to, and you leave enough money to clear the debts. The Prophet sallallahu alaihi wasallam would attend. Remember, we're talking about the Prophet sallallahu alaihi wasallam and the Sahaba. The Prophet sallallahu alaihi wasallam would attend Sahaba's janaza, and one of the questions he will ask is there any outstanding debt on the deceased? And if he was informed, yes, there is, he will then inquire if there is money to clear the debt or a guarantor that will clear the debt on his behalf. And until he didn't have that, he wouldn't lead the janazah salah. And if that guarantee could not be provided, he would say to the Sahaba that read the janazah on your brother. He wouldn't even lead the janazah namaz. Yeah? The severity of the situation. Yeah? And the new generation are quite accustomed to living in debt. Yeah? Credit cards is just like nothing. So keep this in mind. And I've quoted one of the incident over here. But that was the general ruling. And then the third stage is about will and inheritance. So we found out that all the bills, debts, all that was costing £3,000. From the £8,000 we've cleared the debts. We've got £5,000 left. Yeah? A bequeath or a will or a bequest, right, is that you leave certain instruction behind, that after I pass away, I want £1,000 to be given to the Sufa Institute, for example, or to my neighbor. Yeah? Or throughout my life, my neighbor has been helping me throughout my life and taken care of me. They will not inherit automatically, so I want to leave something behind for them, £1,000 for them. You move on to the will at stage 3. Yeah? And after that, so there was will for that £1,000, that will be deducted, and there are certain rules in relation to how much you can include in your will. We will cover that inshallah tomorrow, right? But over here we've taken 1,000 out of 5,000. We've got £4,000 left, and this is where we come to inheritance. So the inheritance will start off from what's remaining after stage 3. Yeah? So in our case, we're left with £4,000. That will go to the inheritors. We need to find out who the heirs are. Which family members will get her share. Because as I mentioned yesterday, that Quran determines each individual shares. Yeah? So who's going to get what has been determined by the Quran and Ahadith and Ijma, and that is stipulated, and that will be distributed accordingly. Yeah, that happens at the stage 4. So these are the 4 stages. Yeah, just keep that in mind. So first of all, after determining what is the ownership of the deceased, we use that money for funeral costs. Then if there's any money left, we clear the debts. If there's any money left to then consider the will, and then if there's any money left after that, yeah, then that will be distributed. Obviously these 2 stage 3 and 4 are interlinked, and that will be discussed inshallah tomorrow. Any questions so far what we've covered? As I said, inshallah tomorrow we will go into the discussion about will. Yeah, what is a will, what you can include in it, will, and what you can't. What is a valid will? When is it forced to have a will? When is it sunnah to have a will? When is it haram to have certain types of will? So that we will cover tomorrow. How can that be legally accepted according to the law of the land? We will look at that. And inshallah, lastly, we will then, I will direct you to a template of a will. Yeah, inshallah. Subhanallah wa bihamdihi, subhanakallahumma wa bihamdik. نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك سبحان ربك رب العزة عما يصفون السلام على المرسلين والحمد لله.